Welcome back, everybody, to our studies in the law of tort for the SQE specification. This lesson is going to spend some time in more detail focusing on what is known as the Caparo test, the test in the case of Caparo and Dickman. Now, this is a test that is useful for establishing a duty of care in truly novel situations, i.e. outside the clearly established categories. We'll talk about the case itself, we'll talk about some of the facts of the case, and we'll then think about how the basic three-part test in Caparo has been elucidated and refined in the subsequent case of Robinson as a sort of way of really honing in on where there are truly novel cases for the establishment of new duties in negligence situations. So as a basic background and introduction then, as we have noted, the duty of care is the first element in a negligence case. If we think about the sort of so-called equation of negligence, where you have to add up all the different parts of it to get a successful claim, the first of these so-called parts of the equation, so-called expressions, is this idea of a duty of care. There has to firstly be a duty of care. There then has to be the establishment of whether or not this duty of care has been breached, i.e. has the person, through their acts or sometimes their omissions, fallen below a certain standard, a standard of care. But then you're not done there. There has to be an amount of causation. In fact, there has to be remoteness, and there also has to be damage. Okay, and then a final one that I haven't noted here on this slide is that there has to be no successful defence. There has to be no defence to the actions that have been committed or the failures to act in the case of omissions. The modern framework for a truly novel case then, i.e. new cases, is found by the test of Caparo Industries versus Dickman from 1990. So this was a case in which Caparo had bought shares in a company called Fidelity PLC, a publicly traded company, Fidelity PLC. And in doing so, they had depended on the audited accounts, a set of audited accounts that had been prepared by the defendant Dickman. Now, Dickman, through these audited accounts, came to the conclusion that the company Fidelity Public Trading was a company that was in profit, when in reality it was a company that was actually suffering from a loss. There was actually no profit there to be had. Caparo made the decision to buy shares in this company, relying on this audit, claiming that they were in profit. And so, when the Caparo claimed losses, when it found out the truth, there was obviously a case to be had against Dickman in terms of failing to prepare adequate accounts. Was Dickman negligent and therefore causing harm to Caparo by not being very, very good in their job, falling below a duty of care, falling below a standard of care in their duty to accurately rely on the preparation for auditing accounts? Well, the House of Lords, if I just very quickly jump to the conclusion of this case and jump to what the House of Lords said, they said that there was no duty of care to Caparo in this situation, and they clarified in doing so a three-stage test for where the duty of care may exist. So there was no claim to be had because there was no duty of care, but it invited the courts to consider, well, what in fact is a novel duty of care? How do we determine a novel duty of care? The key point here is that Dickman did not know Caparo existed. The accounts were prepared for the company's shareholders more generally, and they were not prepared for outside individual investors, so proximity was lacking specifically. But there is more to this story, and really the conclusion of this case is less important than the test that is established. Lord Bridge, as well as others in this case, set out three major ingredients, three major elements that is required for establishing a duty of care in truly novel situations. It is found that these must each be satisfied as well. So the first of these is foreseeability. The harm, the loss or damage must be reasonably foreseeable as the result of the defendant's conduct. This is an objective test. Basically it invites the courts to ask, would a reasonable person in the position of the defendant have foreseen risk of harm to someone in the position of the claimant? Now, in the case of Caparo, there might have been reasonable foreseeability. There might have been a reasonable foreseeability in the case of Dickman, thinking that a person like Caparo, or a company like Caparo, or organization, I believe, like Caparo, would have maybe suffered a loss if they had utilized only their audited accounts as through the purchasing of shares. The next question is whether or not there is proximity. There must be a sufficiently close relationship between the claimant and the defendant. This is sort of elucidated by the basic principle of neighbourhood, relational proximity. It can be spatial, temporal, causal, relational, as I've already mentioned. Now, this is a very important part when we apply this test to Caparo, the actual facts of the case, because in Caparo, the auditors did not know of Caparo Industries plc, and so there was no proximity. They had no knowledge of, and they had no relationship with. There was no spatial relationship, no spatial proximity, no causal proximity, anything at all. The final question is, even if there is reasonable foreseeability, and even if there is proximity as well, it might still be inappropriate to impose a duty of care. And that might be because there has to be policy considerations that the court has to make when thinking about applying a duty of care. So, for example, there might be policy factors resulting from floodgates litigation. There might be the potential for indeterminate liability. There could also be the fact that there might be certain public authority functions to impose, and so to impose a duty might impede on the public authority functions of certain public institutions. So even if there is foreseeability, even if there is proximity, that the imposition of a duty of care must also be fair, just, and reasonable. Then, if all three of these are met, then a novel duty of care is likely to arise. If not, then there is no duty, and a case for negligence will fail immediately. So, of course, this has been treated with later future developments. In the case of Robinson and Chief Constable of West Yorkshire Police from 2018, the Supreme Court clarified that essentially the Caparo test is not always needed. It didn't overrule Caparo in a broad sense. It sort of refined where Caparo is to be applied. It stated that in well-established situations where precedent has already defined a duty of care, the courts do not need to run through all three limbs of the Caparo test afresh. They don't have to just keep applying the Caparo test every single time. And so the Supreme Court in this case is stressing the approach to be incremental. Rather than inventing new duties in completely novel situations, ask whether there are first, existing precedent, and then second, whether there are analogies to existing precedent. So maybe there isn't exactly a precedent that applies exactly in this circumstance, but there might be a similarity in a different kind of precedent that we could sort of reason by analogy that if a duty of care exists in those factual circumstances, then it might be the case that a duty of care can exist in these factual circumstances. And then whether or not, thinking about this, whether or not extending this by analogy to this new circumstance is justified, explaining why this analogy basically works. Now, obviously, public authorities will often face the Caparo test or something relating to it in this kind of regard because of policy and public law concerns. Courts are particularly cautious about imposing duties which might carry broad public burdens or broad public liabilities. But fundamentally, that's why we see a refining of the Caparo test in this particular case, because this case concerned actions that had been done by the police and whether or not the police have a duty to think about and to have a duty of care to the general public when doing things like police stings, when they're trying to apprehend somebody who they suspect of committing a crime.